Hi everyone, it's Professor David Opterbeck, and as promised yesterday, I'm making this video to give you some information on health and educational privacy that we didn't have an opportunity to get to yesterday in the SIP-US bootcamp. So let's start with medical privacy and health information, and there are several statutes you need to be aware of, but the primary one is HIPAA. HIPAA stands for the Health Insurance Portability and Accountability Act of 1996, HIPAA, not HIPPA. HIPAA applies to covered entities or business associates holding protected health information. Now, as you'll see, the substantive requirements of HIPAA are really consistent with the FIPS principles. So I actually don't think the substantive requirements of the HIPAA privacy rule are that difficult. There's also a HIPAA security rule, which we'll talk about, and that's basically a kind of reasonableness assessment. So I don't think that's all that difficult either. And this part isn't really difficult either, but I think it's a piece that you need to focus on so that you keep it straight on the exam, which is what is PHI as opposed to sort of ordinary PII, and what is a covered entity, and what is a business associate. So let's start with PHI. Protected health information is, like all PII, individually identifiable, but it is health information, which means it relates to a physical or mental condition related to the provision or payment of health care. Now, identifiable, of course, as with PII, means it directly identifies or reasonably can identify a specific person. HIPAA also applies to electronic PHI or ePHI, and we'll see how that also relates to the security rule in a moment. HIPAA does not apply to de-identified health information, which by definition would not be PHI because it's not personally identifiable. So, for example, if we have a hospital that has all of its treatment records, and the cardiology unit has records of all of the cardiac catheterizations performed in the past year. And those records are linked to specific names of patients. Well, that linked information is PHI. Now, if we can delink that information because we want to use it for some kind of study, external study perhaps, on techniques and outcomes in cardiac catheterization, and the records can't be traced back to an individual, then it's de-identified and it's not HIPAA information. All right, so let's talk about who is covered. Covered entities are providers, healthcare providers, that is doctors, hospitals, and the like, health insurers, and what is called in the statute health clearinghouses, which are entities that are helping process health information usually related to the insurance claims process. A business associate, which is also covered by HIPAA, is an individual or an entity that is not an employee of a covered entity, and that performs services or activities involving PHI on behalf of the covered entity. So, for example, billing services. If we've got those records of all the cardiac catheterizations and the hospital uses an outside billing service that does accounting and prepares the bills and sends out and collects the payments. And those records are identifiable because they're sending it to the person being billed or to their insurance carrier, then that is a business associate. So business associates are also covered under HIPAA. They may be subject to direct liability under the privacy or security rules, or maybe subject to liability through an agreement between the covered entity and the business associate to comply with HIPAA rules. And if you work in a covered entity as a lawyer or a compliance professional, and you're dealing with agreements between the covered entity and the business associates, then it's likely that one of your jobs is going to be to make sure that those contractual arrangements properly specify the scope of the HIPAA obligations and the responsibilities of the parties. So as alluded to a little bit, there are two main components of HIPAA, which is the privacy rule and the security rule, and we'll talk about each of those rules in a moment. There is another statute which we'll also talk about in a few moments, which is the HITECH Act. And the HITECH Act is really an amendment enacted in 2009 that modified parts of the privacy and security rules. So let's talk first about the HIPAA privacy rule. Now, the good news about the HIPAA privacy rule is, in a sense, it's relatively easy if you understand the FIPS, the Fair Information Privacy Practices. And as we said throughout the day during the in-person part of the boot camp, the FIPS underlie all of these different privacy regimes that we're talking about, and if you understand them, you'll be pretty far along the way to knowing what the details of the rule is. So the HIPAA privacy rule requires detailed privacy notices. That form that you get in your doctor's office, that you sign, is giving you the notice of your rights and of the provider's responsibilities under HIPAA. It also requires a written authorization from the data subject for any disclosure of HIPAA-covered information. This authorization needs to be specific, and a provider or an insurer cannot condition the provision of treatment or the payment of insurance benefits on signing an authorization to disclose the covered information to somebody else. Now, there is a really important exception you should be aware of, which is that the use or disclosure of PHI for treatment or for payment or for healthcare operations of a covered entity or a business associate does not require a written authorization. So the form you get that notifies you of your HIPAA rights is going to tell you that the provider, your doctor, your hospital, can use PHI internally in order to provide you with treatment. And if you think about it, that makes sense. You wouldn't want, the possibility of actually gumming up the patient's treatment by having to get a signed authorization every time the doctor looks at your chart. So we're talking really here about disclosures to others. Now, further looking at how the HIPAA privacy rule implements FIPS, there is a data minimization piece of it. There is a right of access and of amendment for the data subject. And there are different administrative requirements, including that the covered entity have a privacy officer and including that there be training of employees. Let's look now for a moment at the HIPAA security rule. In the HIPAA security rule, and remember throughout the day during when we met together, we talked quite a few times about how security and privacy have to go together. You can't have privacy without security. And the HIPAA security rule is a good example of a regulatory structure that implements that principle. So it applies to technical, physical, and administrative standards for ePHI, for electronic PHI. The basic requirements, the first one you can see relates to that CIA triad. Ensure the confidentiality, integrity, and availability of ePHI. Identify and protect against reasonably anticipated threats to the CIA of that information. Protect against reasonably anticipated impermissible uses of the information, and ensure compliance by the workforce. Now, the HIPAA security rule doesn't give an absolute standard of what an organization needs to do to comply. It recognizes that there are going to be covered entities and business associates of widely different sizes and complexities, and that can only reasonably implement, some degree of security measures. So the kind of analysis the entity has to go through is really a sort of risk-benefit kind of analysis, which will be familiar from really generally any sort of risk management measurement. So what is the size, complexity, and capability of the organization? What kind of technical infrastructure does the organization have? What would be the costs of different kinds of security measures? What is the likelihood and possible impact of the risk to ePHI from different possible vectors? And so part of the job of the lawyer or compliance professional who's trying to help a covered entity or business associate comply with the security rule is to go through a balancing analysis like this, and as a best practice to document it. There are some additional requirements within the security rule beyond that sort of first analysis and then implementation. of the security measures. There must be an individual in the organization who is responsible for overseeing that implementation. There must be ongoing risk assessments. And again, those ongoing risk assessments really represent or show the common themes in ways of managing or measuring risk. So what's the potential likelihood and impact? What kind of security measures? Documenting measures that have been taken, and continually responding to the environment and adopting reasonable security based on the principles we saw about the size of the organization and cost and so on. And the organization must engage in regular workforce training around data security. So we mentioned the HITECH Act as an amendment to the HIPAA privacy and security rule. And two key pieces that we want to note for the purpose of the SIP exam. The HITECH Act states that any unauthorized use or disclosure of EPHI it creates the presumption that there has been a data breach and that the information has been compromised. And in the event there is a data breach, there is a notification requirement, a data breach notification requirement to the individuals affected within 60 days. If the breach affects more than 500 people, to notify the Federal Department of Health and Human Services. If the breach affects more than 500 people in the same jurisdiction, to notify the media. And as a business associate, to also notify the covered entity for whom they're processing PHI that there has been a breach. So these are pretty significant notification requirements. Note that they are in addition to whatever requirements may be imposed under state data breach notification laws. HIPAA is enforced by the Office of Civil Rights within the HHS. The Office of Civil Rights will process complaints, will do audits, will impose civil penalties. The U.S. Department of Justice imposes criminal penalties, relatively rarely, but for very significant violations. And note also that HIPAA does not preempt state law, so that there also can be enforcement of privacy violations under, for example, general state data breach laws or other state laws that might cover HIPAA protected information. Now remember, when we talked about comprehensive state laws, we noted that most of them, for example, California, carve out HIPAA information, and they leave that enforcement to OCR and into those extreme cases to the DOJ. We also noted, however, and this is one of those places where you can get a bit of a trick question, remember that HIPAA applies, the requirement is the kind of information, it's PHI, and the kind of entity. It's a covered entity or business associate. So a seller of an app, a health tracking app, is not likely to be a covered entity, and may or may not be a business associate. It depends on whether it's getting data from a covered entity. Likelihood not if it's just sort of a tracker, that fitness tracker the individual is wearing, in which case you're not carved out from the comprehensive state law. So you do need to be a little bit careful when you're managing compliance in that space. The last piece that we need to cover is education records and technology, which is chapter 10 in the book. And the primary law that you need to be aware of is FERPA, the Family Educational Rights and Privacy Act. This law applies to all educational institutions that receive federal funding. If you remember all the way back to the beginning of the live portion of the boot camp, we talked about the structure of U.S. law and U.S. government. Remember that it's a federal system. You have the federal government, you have state governments, and the main way in which the federal government can regulate things that are happening within the states is through the Commerce Clause, as well as through what's called the Spending Clause and the Taxing Clause in the Constitution. So if the federal government spends money, it can attach conditions to that money. And so here we have educational institutions that are receiving federal money in the form of grants and also in the form of student loans that have to abide by FERPA, and that really is pretty much all or most institutions of higher education in the United States, as well as lower grade schools. FERPA applies to information stored in education records that are directly related to the student, maintained by the educational institute or on its behalf. And it does not apply merely to a student directory. So the key things you need to be aware of, questions is it an education record? Is it directly related to the individual student? Is it in fact maintained by the educational institution or on its behalf? FERPA prohibits schools from disclosing the records, including grades, financial aid, or behavioral, without the students' or the parents' consent. Now, if you're of an age where you've had a student go off to college, as I have, you'll know that there's a big change with educational privacy once that child hits 18 and becomes an adult and then heads off to college, because when they're a lower school student, if there are FERPA records, or if there's related state law, and by the way, there is in pretty much every state related state laws about educational records, although the test is primarily about FERPA. Right, as the parent, you have the ability to see those records, but when the child turns 18 and then goes off to college, without the child's consent, you as the parent don't have the right to see those records. So, part of what you have to negotiate with your child is whether you're gonna have that child's consent to see how they're doing in school. It gives students or parents, in the case of a minor student or if there is consent, right to access and amend the records if in fact there is an error. An interesting aspect of FERPA, particularly coming through the COVID period, relates to educational technology, what we call EdTech, and private companies that are offering online hosting for classrooms. So for example, Google Classrooms. So an entity like Google is not an educational institution that's receiving federal funding relating to education, so it is not going to directly be covered by FERPA. So how does the entity like Google, if it's Google Classrooms, get the educational information from the school? Usually it is provided under an exception in FERPA called the school official exception. And this exception is pretty broad, and it allows a school official to disclose FERPA information for education-related purposes. And so a school official can, under FERPA as it is currently written, disclose to an entity like, say, Google, if it's hosting Google Classrooms, FERPA-related information. And one of the difficult things or challenging things with this is that since Google itself, for example, is not regulated by FERPA, there are pretty few limits on legally limits on what they can do with the information and on what other information they can collect from the students. And of course, Google Classrooms is collecting usage information and other information to develop the product, but also for their own monetizing and marketing purposes. So some of these providers of EdTech have entered into a voluntary self-regulation pledge to safeguard student privacy and to avoid targeted ads, but that's merely a self-regulatory pledge. Another key piece of this is the school official who's disclosing this information. The educational institution is supposed to maintain control over the entity to which the information is disclosed, primarily through contractual provisions. So theoretically, there should be a contract between the school district or the school and the EdTech entity that is receiving certain information. That contract can require that the entity adhere to FERPA, and it can include other limitations on what the entity can do with the data. But the problem is, especially in the difficulties of the COVID pandemic, very few school districts have the resources to really know what these agreements say and to monitor them. So that's a bit of a problem in the K-12 arena. It's also a problem in the higher education arena, although at least theoretically it should be less of a problem because there should be more resources. And if you're in compliance, in privacy compliance in an educational institution, then the question of EdTech will definitely be one of the things that you will have to keep an eye on. So this is the end of this supplemental presentation. I hope you found it helpful, and I appreciate your time and your attention.